So let's talk a little bit about probate. So probate is both a court and a process. And typically when we say probate, we're referring to the process of probate, which, as we know, can be super long and be a lot of work for the personal representative or executor or administrator. And it's also the source of a lot of drama. We hear about people who die without a will, and of course, we still need probate to determine where those assets should go. So probate gets a bad rap because it is a public process, and it can be expensive depending upon the state that you're in, because the cost of probate is typically a percentage of the assets that go through probate. Of course, as we've talked about in previous chapters, not everything goes through probate. You've got other assets that pass outside of probate directly to either your joint owner or via contract. And anyway, so a lot of this chapter is going to build on what we learned before and will reinforce some of the things that you've already learned, including the idea of dying without a will versus with a will. If you die with a valid will, it's called dying testate. If you die without a valid will, it's considered dying intestate. And if you inherit under a will, you are a legatee. And a person who inherits under estate intestacy laws is called an heir. Now, we use these terms, especially that term heir, in a more generic form to mean, almost anybody that inherits, but the true definition, at least the definition that we're using in this course, is that an heir is somebody who inherits under intestacy laws. But you have to be prepared to also recognize that it is also a term that's used generically, just like beneficiary is both a very specific, has both a very specific meaning and generically speaking. And a devisee is a person who inherits real estate under a valid will. So you could be technically, you could be all three of these things. You could be an heir and be somebody who would be entitled to receive an asset under state intestacy laws if that person died without a will. But if they died with a will and you're still technically a part of that group of heirs, but if you are listed in the will as somebody who's going to inherit, you would be a legatee. And if that thing that you're inheriting is a piece of real estate, you'd be a devisee. So the advantages of probate: it protects the decedent and makes sure that those assets that don't have any other way to legally transfer, like, jewelry or art or things of value that don't really have an official title, that we can't title to a trust, we can't title it jointly, that those assets go where the decedent wants them to per their valid will. It also, therefore, protects legatees and heirs. So if you and your sister both want grandma's china, and of course grandma's china doesn't have a title, and she puts it in her will that it gets split even Steven between my two granddaughters, and your sister tries to, take the whole thing and says, this is what grandma wanted. It's in her will. She wanted us to share it. So it protects heirs as well. It can also protect heirs in the event that they want to say, hey, that will was bull. It was not valid. It was created without sound mind or mental capacity to make the will. So it protects heirs who are questioning whether or not that will is legit. It also protects heirs because it gives you clean title. And it protects creditors because creditors want to be paid. Here's a funny thing, though, when it comes to debt that you have upon your death. So let's talk about these. Let's talk about what happens. Let's say we've got a decedent. We'll name Pat. Sorry, Pat. You died. He's not happy about it. And Pat was pretty young, and he had just graduated, and he had a credit card bill of, let's say, $2,500. So Pat has really just debts. He might have a little bit of cash, but let's ignore the cash. Let's say Pat had no money in his checking account. Visa is going to get stiffed. So they're just going to have to write that off because there is no money to pay it in Pat's estate. Now let's look at another situation. Let's say Pat had $1,000 in savings, titled to him only. Well, that means that Visa is going to show up if they receive notice, as they should, of Pat's death, and that liquidity that's in Pat's estate is going to have to be used to pay both, probate fees as well as this credit card debt. Now, who stands in line first, I don't know, but I can tell you that if there is any liquidity in Pat's estate that goes through probate, it will be used to pay down his credit card bill. So Visa will get $1,000 in this situation. We'll just imagine they'll get $1,000 or whatever's available after all other fees and expenses have been paid that are first in line, and Visa will have to write off the other $1,500. They'll get some of their money, but they will have to write off the rest of it. Okay, so let's look at another situation. What if Pat instead had a savings account with payable on death on file to mom? Well, then that $1,000 doesn't go through probate, and it's not available for Visa to use because there's no assets in probate. We just mopped up that $1,000. It went directly to mom. So now let's make a slight change to this scenario. What if Pat had a federal student loan for, let's say, $10,000? Federal student loans are extinguished upon the death of the borrower. What if it was a private student loan? What do you think would happen to that? Well, it's anybody's guess. You have to read the terms of the loan agreement. Today, because there are so many private companies that are interested in helping students consolidate their student loan debt, in order to look attractive, many are offering this benefit. Of course, it probably comes with a slightly higher interest rate, but anyways, I just wanted to talk a little bit about that because it's one distasteful thing that occurs occasionally when people die. Sometimes people have significant bills that are outstanding and no money in probate. And so the bill collector will call and say, I want my money. They'll figure out who the next of kin is, and they will try to scare next of kin into paying off the decedent's debts. Unless you were a joint debtor, unless that credit card was in your name too, you don't owe anything. The big caveat to that is spouses. So if you get married and your spouse takes out a big loan or racks up credit card debt, you might be held responsible for that depending upon the state that you're in. One of the big disadvantages of probate is it's just a long, drawn-out process. It's super time-consuming for the person who's dealing with your estate. So, again, your personal representative or executor, depending upon the state, or administrator if you died without a will. And it can be expensive. Wisconsin's probate costs are pretty low, but it's going to be a percentage of whatever assets go through probate. Also be super expensive to have a piece of property in another state that goes through that state's probate, which is called ancillary probate. And technically, it is not private. Your probate details are public.
Hi, I'm Danielle of Trial and Errors.
And I'm Andy. James Gandolfini recently passed away tragically at the age of 51 after a sudden heart attack. Strangely, given the size of his estate, he used a will as the primary tool to pass his assets on to the next generation.
And because of that, we're seeing lots of estate taxes that could have been avoided. And on top of all the estate taxes, we have something else interesting going on. Supposedly there's brewings of trouble between his first wife, the mother of his 13-year-old son, and his widow, who is the mother of his young daughter. Could be fighting, we'll see. Because it's a will, though, it's going through the probate court.
And that's the problem with using a will. One of the problems is that every will has to pass through probate court in order to be effective. Probate court is expensive, it's time-consuming, it's a breeding ground for fighting, and it often leads to trouble.
It does. But of course there's something else with his estate, and we see this a lot. A lot of times parents leave money to minor children. In this case, it's millions of dollars that they'll be receiving at the ages of 21 and 25. Maybe not the best idea.
It's interesting because we saw this exact problem play out in the Whitney Houston estate. Whitney Houston left the bulk of her assets to her daughter, Bobby Christina, with a large chunk coming at age 21, the rest at 25, and then at age 30. And Whitney Houston's family didn't like it. They went to court to try to change things, saying that's really not what Whitney Houston wanted.
Yeah, most parents don't want their kids getting hundreds of thousands of dollars in their 20s, let alone millions of dollars like we have in the Gandolfini estate and the Whitney Houston estate as well. So this all could have been avoided with some proper planning.
Yeah, the Whitney Houston effort, they failed. They were not able to change the will, so Bobby Christina is getting money starting at age 21. And we expect the same thing's going to happen with James Gandolfini, that his wish is in his will, even if the family doesn't like it, even if they think they're not ready for it, they're going to be stuck with it.
Stay tuned. We'll keep you posted at trialandairs.com.
So this video was posted on their website in July of 2013, and they, of course, couldn't have known that Bobby Christina was going to be dead within 2 years. She died in July of 2015, sadly. Bobby Christina, born in 1993, was a minor when her mom died in 2012. Her daughter, who was born in 1993, would have been, 19 at the time? Whitney left everything to her daughter, and she left it to her via her will, which contained a testamentary trust, which we'll learn more about. But a testamentary trust is created upon your death. And Whitney's assets went to this testamentary trust upon Whitney's death. Now, Whitney had more than just the assets that she had earned during her lifetime. She also, of course, has royalties from her music forever. So it's worth a lot more probably in perpetuity than what she had at the time of her death. So the fact that she used a testamentary trust, which is inside of the will, makes it a far more public process. Now, she only gave Bobby, she indicated that, so the testamentary trust allowed for Bobby to get 10% of Whitney's estate at age 21, which Whitney's surviving family members, not including Bobby, of course, said that that is not a good idea and that should not happen. But as we all know, it did happen. So 10% of her estate would have been about $2 million. So in 2015, Bobby Christina dies, and she never lived long enough to get the next chunk of cash that was to come her way, which was another maybe $3 million that she was going to get. And then at age 30, she would have gotten it all. So the question that's interesting is, well, then what happens to Bobby Christina's estate? Well, because the assets went into this testamentary trust and the terms of the testamentary trust laid out, here's what Bobby Christina should get as long as she's alive at these ages. But if she's not alive and if she has no children, then the remainder of the estate would go to Whitney Houston's two brothers and her mother, Sissy. The other interesting thing that comes up is that Bobby Brown was also listed in this will. This will, by the way, was created in 1993, the year that Bobby Christina was born. So it's likely what spurred her to create this will. And at the time, she was married to Bobby Brown, and eventually they divorced. But this original will from 1993 says, I'm going to leave some stuff to my husband, but since he's no longer her husband, and we've read about that divorce statute, then he's no longer going to be able to inherit under the will. The other statute that comes into play is the felonious homicide statute, which is outside of this testamentary trust. Because so far we've just been focusing on the assets that were in the testamentary trust. We know that at age 21, Bobby Christina received $2 million. Now, it's possible that all of that was spent before her death, but that money would have come to her personally, and it would have been part of her own probate estate. And Nick Gordon, the boyfriend there was never any formal charge, but well, it was questioned whether or not Nick Gordon was responsible for Bobby Christina's death, and so that would likely have prevented him from being able to inherit. But it's unclear if that ever happened, because of course, as you probably know, Nick Gordon died earlier this year from a heroin overdose. Anyways, the Whitney Houston case, the James Gandolfini case, Prince, so many others provide us with lots of great information to use as we analyze what some of these options that you have available can accomplish for you, especially when it comes to probate. So we know all of these things about all of these celebrities to the extent that their estates or portions of their estate ended up in probate. Because you can maintain privacy if you pass assets outside of probate. And that's the lesson that we want to emphasize here. Okay. Non-traditional relationships were the issue of making sure that you are able to pass on property to somebody you care about who you might have a non-traditional relationship with, or to somebody that you think is going to be controversial. The whole point of this section is to reinforce the idea that there are lots of ways that you can give gifts to people you love, whether it's before death or after death, without it going through your will. And that's really the better approach. Relying on a will to make a gift can be risky if the person you're trying to leave the asset to is going to create all kinds of controversy with your family. You just don't, if you want to avoid that, find another way. So the probate process is different in each state, but it always begins with someone producing a will and then opening or petitioning to open the estate. And if there's a valid will, the executor is appointed, or if there's no valid will, the administrator is appointed. Letters are issued. A bond might have to be posted. Oftentimes you can put in your will that, your executor doesn't need to post a bond. And then if you're the personal representative or executor, you are now responsible for managing and distributing the estate. And that includes, marshaling the assets, making sure that you post legal notices of the death, also paying any debts and costs and taxes according to what the decedent's will indicated in terms of what assets are supposed to be used to pay those costs, and then put together an inventory. If the will included a specific bequest, I give my nephew Jason my 1982 Camaro. If that Camaro no longer exists, then Jason isn't getting anything, if that was the only thing that he was supposed to get in the will. So it's considered to have become extinct because it's gone. And then abatement refers to the lack of funds to be able to satisfy specific dollar value bequests. So if the will stated, my nieces and nephews shall each receive $25,000, and you have 4 nieces and nephews, so a total of $100,000, but you don't have $100,000 worth of cash in your probate estate to split. And again, this is probate. So there could have been assets that passed outside of probate. Let's say there's plenty of life insurance. Say there was a life insurance policy for $1 million that went to the spouse, and the will says, give $100,000 to my nieces and nephews, $25,000 each, and there's no cash in the probate estate to do it, then they are not getting anything. You can't reach to assets that passed outside of probate to make those bequests. So if there is money available, however, for those specific bequests, then it will be proportionately distributed. They won't get the whole thing, but it will have been reduced or abated. The property that goes through probate, of course, is property that doesn't have some other direction associated with it that says, this is where I go. So what passes through probate? Sole owner, tenancy in common, community property, and messed up beneficiary designations. Now, sometimes people will say, to my estate, which maybe they've got a good reason for it, but generally that's not advisable as a beneficiary, because then you've essentially, now you got to go through probate, and that can create problems, as we've learned. And invalid beneficiaries, of course, beneficiary designations are used for life insurance and annuities, retirement accounts. Also, if you've got a payable on death or a transfer on death, and the person that you were going to have it payable to or transferred to predeceases you, then of course we're going right back through probate. So property that passes outside of probate includes anything that passes via contract law. Life insurance, annuities, and retirement accounts are all considered contracts. I want to spend a minute talking about literally what happens with these different pieces of your estate when you die, because it's all a little bit confusing. So let's start with life insurance. Life insurance contracts have an owner, an insured, and a beneficiary. And of course, we have an insurance company behind the whole thing. So the insurance company is, of course, trying to sell you policies, and they might come to you and say, hey, you should buy some life insurance. And you're like, why? And they're like, you should have some for liquidity in your estate. And you're like, oh, yes, that's right, I should. So you might buy life insurance on yourself with your estate as the beneficiary, or maybe your loved ones. So you can be the owner and the insured, but not the beneficiary. If you're the insured, that'd be pointless. And I'm going to use myself as an example. So Lisa is the owner, and Lisa, in this case, is going to be the insured, and Max, my son, is going to be the beneficiary. And let's just say that this is a plain vanilla term life policy that has no cash value. So it's a term life policy with no cash value. Let's say it's $1 million in death benefit. So while I'm alive, what is this thing worth? It's worth nothing while I'm alive. I mean, other than my peace of mind is worth something. But it's worth nothing to me while I'm alive. It's worth nothing to my beneficiary while I'm alive. The only time that it becomes worth something is upon my death. And upon my death, as long as Max is alive, he will receive the death benefit proceeds. And it'll probably take a week or two for him to process the claim. Probably longer the bigger the death benefit. But so he would receive $1 million upon my death. It passes outside of probate. They don't need my will to know where to pay the $1 million to. They have my beneficiary designation, which is Max. Now he's listed as my primary beneficiary. I might have a successor beneficiary, and I might say to my spouse. To the person to whom I'm married at the time of my death is a popular way now that they'll freeze beneficiary designations just to make sure that it doesn't go to an ex-spouse. So no probate for this $1 million. Oddly, and this is something that's going to come up, and I just want to introduce the concept now, even though while I was alive it didn't have any value to me, upon my death, because I'm both the owner and the insured, that $1 million is going to be in my gross estate. The IRS is like, look, lady, you created wealth by buying this life insurance policy, and it paid off. Congratulations. That $1 million is going to show up in my gross taxable estate because I was the owner of it. Now, how could I have avoided that? If I would have made a trust, an irrevocable trust, the owner of that policy, then it would not be in my gross estate. But in none of these circumstances does that term life policy end up going through probate. The only way it's going to go through probate is if my beneficiary is listed to either be the estate, then that benefit goes through probate to know where to go. The other way that the estate becomes the beneficiary is by accident if all of the beneficiaries that are listed predecease the insured. So let's talk about a slightly different situation now. Let's say instead of a term life policy, it's a whole life policy or a universal life policy that has cash value, also known as permanent life insurance. And let's say instead of it being no cash value, let's say it's worth $100,000. Well, I'd still have it be $1 million death benefit. Let's say cash value is $100,000, which just means I've owned this thing long enough and I've paid in enough premiums that of the $1 million death benefit, $100,000 is going to come from cash value. And it's what makes whole life insurance affordable. It's still more expensive than term. However, that cash value during my lifetime, I could borrow against it if I wanted to. So there's like real cash value associated with this policy. If I dumped this permanent life insurance policy, I'd probably have to pay some surrender charge. But while I'm alive, I could get cash out of it. So it's got a present value. It's worth something to me today. So if I'm the owner and the insured, and let's put Max back as the beneficiary, and if I die today, the proceeds of $1 million still go to Max, and it still avoids my probate estate, but it still shows up in my gross estate as $1 million. Same as with the term life policy. All right, so let's do a new twist on it. Let's say I am the owner and the beneficiary, and the insured is Max's dad, which is actually a true scenario. Max's dad. So I had life insurance taken out in the event that Max's dad died. I'm the owner of this policy, so I control it. He's the insured. He's just the life that I'm insuring, but I'm also the beneficiary because I want to be paid in case something bad happens to him. And let's say it's still a permanent life insurance policy. It's got a cash value of $100,000, death benefit of $1 million. If I died today, what would happen? Again, I'm not the insured. I am just the owner. So if I died today, that policy, that life insurance benefit isn't triggered because the insured is still alive. But somebody wants this policy because it's got value to it. It's worth $100,000 worth of cash. And so upon my death, again, the death benefit wasn't triggered because I'm not the insured, but this is an asset. It's worth $100,000. This policy needs to change owners. Who's going to be the owner now? And also that owner will determine who the beneficiary is going to be. So with life insurance, occasionally the company will have you name a successor owner. That is a person to whom you want the ownership of the policy transferred in the event of your death. This is usually what they'll do in the event that you own a policy where somebody else is the insured. So let's say in this case, the new owner is going to be Max. Maybe I've named a successor owner, and Max is going to be the successor owner. So it will automatically transfer to him if I've named him as a successor owner. Otherwise, it's going to go through the estate. So hopefully you've named a successor owner, and maybe that successor owner, Max, would name himself as beneficiary. He would just like slide right into my old spot. And in my gross estate in this case will be the $100,000. And if there was a successor owner, the probate estate is going to not be applicable because it transferred outside of probate. If I didn't name a successor owner, then my probate estate would have to figure out who gets the value, who gets this policy that's worth $100,000. So the life insurance company would just have to stand by while we figure all this out. And then a new owner would be named, and then they could slide right in, which in this case, it would likely be Max. And the same thing would be true with annuities, depending upon the status of the annuity and whether or not there was any value to the annuity after the owner's death. That will determine whether or not there is any asset to be passed, and it will determine who it goes to. If you name a successor owner on an annuity, just like a life insurance policy, then hooray. I almost need to do a whole separate discussion on life insurance and annuities. So with retirement accounts, you can have a traditional IRA, a Roth IRA, a 401k, or a variety of other employer plans, a simple, a SEP, 403b, a deferred comp, 401a, or if it's with the federal government, the thrift savings plan. All of these, and probably several others I've forgotten about, these are all different kinds of retirement accounts. And with each of these, you've received some kind of benefit from a tax standpoint. The owner, the original owner of these accounts, if it's a traditional IRA, all of the money that's in that account has never been taxed. And with a 401k, you might have both pre-tax and Roth money in it, with the pre-tax money never having been taxed and the Roth money never being taxed again. That's the best thing about a Roth. You paid taxes on the money going in, you never owe it again. So let's just focus for a moment on the pre-tax version. So traditional IRAs, pre-tax 401ks, and then pre-tax simple SEPs, 403bs, 457, 401as are almost always all pre-tax. So you could have both in a TSP. So with pre-tax retirement accounts, during the owner's lifetime, you put money in on a pre-tax basis, meaning you didn't pay taxes on those dollars that got invested. And you're making a deal. You're saying, look, I'm going to enjoy this tax break today because it escapes federal and state income tax on my earnings that I decided to shelter inside of this account. And when I go to take the money out, I'm going to pay income taxes on 100% of the withdrawal, which is scary because you're like, I have no idea what taxes are going to be when I retire. I hope they're not bad, but you don't know. And the IRS also says, look, it might be that you've saved enough money in other accounts and maybe in a taxable brokerage that you think you're going to get away with not needing this IRA money in retirement. Well, too bad, so sad. We will force you to take the money out via required minimum distributions. So when you hit, nowadays, it's age 72, you're going to have to start taking withdrawals, whether you need the money or not. And when that money comes out, the IRS is like, thank God, because we needed the tax revenue, right? So RMDs at age 72 for the original owner. Now, what if the original owner dies? What happens to this account? Well, you name a beneficiary, and in most states, they kind of make sure that that beneficiary is your spouse, because spouses have certain rights when it comes to retirement accounts. And if you try to name somebody other than your spouse's beneficiary, your spouse could like march right in and start raising Cain, because they'll be like, hey, that is my money. Anyway, so let's assume that that you are married and you did name your spouse as the beneficiary, in which case the IRS has a special deal if your spouse is the beneficiary, and that is your spouse can just take all of those dollars. Let's say your spouse is only, let's say, 55 at the time of your death. Your spouse can take all of those dollars and put it into their own IRA. Or if, let's say that you were older, let's say you were 60 at the time of your death, your spouse is 55, technically, you're not supposed to touch qualified assets until you're 59 and a half. And so the IRS has another special deal for you. If you're the spouse, you can just simply accept this pre-tax account as an inherited IRA. And so when they retitle it, it will be to you as the beneficiary of this IRA of your spouse. And if you want to, then you can start taking withdrawals immediately, because the original account holder is still on the account. It's a inherited IRA. It still retains the same age as the decedent, and so you can take money out without penalty. But if you don't need the money now and you would rather delay the date that RMDs begin, because, oh, by the way, with an inherited IRA, you keep the original account holder's age. So when the decedent would have turned 72, you have to start taking required minimum distributions if you choose to keep this as the spouse as an inherited IRA. But if you decide that you want to take it into your own IRA, that's fine, you can, but then you lose the ability to access the money penalty-free until you turn 59 and a half. So spouses have a lot more options when it comes to qualified accounts. Now, what happens if it's not your spouse that's the beneficiary? If you have a non-spouse beneficiary, you lose the option to roll that money into your own IRA. And it triggers a whole new set of distribution requirements. I mean, first of all, if you want to, you can just go ahead and take the whole wad all at once. If you're the beneficiary, the IRS is happy for you to take the whole account, at which point you will trigger all kinds of taxes, and there won't be any penalties, but it will trigger all kinds of taxes because remember, that money's never been taxed, and it's going to be taxed at your regular income tax rates. So you can take it all at once as a lump sum. You can spread it out over 5 years, and then you can also spread it out over your own expected lifetime. That gets a little bit more tricky, but you cannot put it into your own IRA. It stays as a beneficiary IRA unless you just want to take the whole amount out now. So again, if it's, let's say it's a $500,000 account that you're inheriting, and you'll be like, oh my goodness, I totally want to take all of it out now. Well, check out the taxes that you would pay. Because remember, we've got a progressive tax system for income tax in the U.S. And so you pay quite a bit in income tax on that lump sum distribution. So you might want to find other ways to spread it out. Now, what if you're dealing with a Roth instead of a pre-tax account? Well, the rules are similar in that spouses can put it in their own bucket and just keep it as their own Roth IRA, and there's no reason why they would keep it as a beneficiary IRA. But they're never required to take RMDs. The spouse isn't, because the decedent never had to take RMDs, because that's one of the best things about, one of many great things about the Roth IRA, besides never having to pay taxes on it again. You also don't ever have to take distributions. So it's a lovely hedge against future tax increases. So if you're a non-spouse, however, and you receive a Roth IRA as the beneficiary, the IRS will require you to start taking distributions. They don't want you to keep that money hidden forever. So eventually RMDs happen from Roths that are inherited, but nobody will ever have to pay tax on that again. So Roths are a lovely thing to inherit. One of many things that are great to inherit. But if you have a test question, if your uncle is going to leave you an IRA, he's got one with $1 million in it, that's a traditional IRA, and one that's got $1 million in it, that's a Roth IRA. Which one would you rather inherit? I'll let you think about that. So other transfers that happen via contract law include payable on death accounts and transfer on death accounts. So those avoid probate, unless, of course, the person named predeceases the decedent, then it'll land in probate. And then, of course, we've spent all kinds of time talking about transfers that happen via title, and that would include joint tenants with rights of survivorship and tenancy by the entirety. And the option in some states to name a beneficiary on real estate. So if you have a house that you own, sole owner, and you want it to avoid probate, you could add a payable on death deed, which doesn't do anything while you're alive. It just triggers the transfer of that asset upon your death directly to a beneficiary that you name. It's not a completed gift during your lifetime, so you haven't really done anything because you can change it at any time, and that future beneficiary doesn't enjoy any ownership rights until you die. And transfers via state trust law, this only applies to property that was actually titled to the trust. And taxable assets like your house and maybe a brokerage account that you own that doesn't have any special IRA wrapper or any other kind of retirement account designation, those you can title to your trust. You can title your car to your trust, but you can't title your IRAs or 401ks to the trust. Those follow you and your Social Security number. You can name a trust as beneficiary to those assets, and that gets pretty complex, and we'll talk more about that in future chapters. I like this slide because it gives a summary of all of the ways that you can avoid probate on your assets if you want to. Again, maybe you don't care. Maybe you're like, fine, I don't mind probate, no big deal. But if you want to avoid probate, here's a nice summary on how you can do that.